My name is Darren Feinblum, and I'm one of the partners at Feinblum and Hanel. For the past 10 years, I've been defending people charged with DUI. But more specifically, let's talk about DUI and multiple offenses. In case you didn't know, the more DUIs they get, the more serious they get. If you've got a second DUI within 5 years, you're looking at a mandatory county jail sentence of 10 days. More importantly, you're looking at a 5-year license suspension. It's still considered a misdemeanor in the state of Florida, but obviously the 10 days in jail is extremely serious. Can we get you out of that jail? Absolutely. Can we fight your DUI? Absolutely. Just because you have a prior, that will never appear in court, especially in a trial. Let's talk about third-time DUI offenders and what the law is on that. If you have a third DUI charge within 10 years of your second, that's a new law in the state of Florida. That can be and will be filed as a felony. And when it's filed as a felony, you're looking at some problems because, one, you can get up to 5 years in state prison, you can lose your license for 10 years, and many other serious consequences. So you need to definitely contact our office. There's a 30-day mandatory minimum jail sentence on that as well. Fourth offense DUI, no matter when it happened, where it happened, anything like that, fourth offense can be and will be filed as a felony. And you'll be looking at 5 years state prison. So let's talk about what kind of defenses you may have in these types of cases. Well, you obviously have the ordinary defenses in every DUI, which is why they stop your vehicle. How did you perform on the field sobriety test? Did you take a breath test? So there's a normal way to challenge the DUI. Still exists just because you have priors, those don't go away. And no one's better at defending DUIs than we are. We're happy to discuss your case with you. But let's talk about a new defense that's kind of come up in the last year or two. The Supreme Court of Florida recently decided a case called Kelly v. State. And what that case talks about, if you were not represented by an attorney on one of those or two of those prior DUIs, they cannot use that to enhance. So you ask, well, how do you do it? How do you defend it? Well, if the state files the case as a felony, and we know that you weren't represented by a lawyer and you couldn't afford one or you didn't properly waive your right to a lawyer, we can file a motion to dismiss that felony charge. And we'll have a hearing with the judge where you'll have to testify that you didn't have any representation or you didn't properly waive that right to representation. And if we get that felony dismissed, they could be out of luck because speedy trial is already run on the misdemeanor. So we definitely have many different ways to defend these cases. Let me talk to you a little about some other alternatives. If your case is not a good one and you have an alcohol problem, clearly if you've been charged more than 2 or 3 times with DUI, you may need some help of treatment. We're also here to help you with that. We have many, many providers across this country and across the state that'll help you get the help you need. One of the things that's important is not only that we defend you on the case, but we get you better. We want to stop you from having this happen ever again, and we're really willing to help you do that. So if you have questions or concerns, or if we can be any help to you, whether you want to fight your case or whether you want to get the help you deserve or any combination of those two, we're the people for you here at Feinblum and Hanel. Give us a call at 1-800-FIGHT-IT or visit our website at fightyourdui.com.